Welcome to Cornell ILR Center for Applied Research on Work webinar series. My name is Timothy McNutt. I direct the Criminal Justice and Employment Initiative. Our event today will focus on occupational licensing restrictions and impact on workers with criminal records. Just a little bit about who we are. The Cornell ILR School was founded in 1945 as the New York State School of Industrial Labor Relations. Our mission is to prepare leaders, inform national and international employment and labor policy, and improve working lives. The Center for Applied Research on Work supports events like this webinar series with an aim towards solving practical problems, informing national and international employment and labor policy, and informing policy making. The Criminal Justice Employment Initiative is just but one of many units within the Center for Applied Research on Work, and our focus is centered on improving economic opportunity for people with criminal records. Before I present our speakers for the day, I'd like to provide a little context about our topic and the systematic problem of unemployment and underemployment of people with criminal records. Studies show that 70 to 100 million Americans have some form of a criminal record. 600,000 people re-enter society each year from being incarcerated. And in New York, around 20,000 individuals are released from Department of Corrections and Community Supervision facilities. Employment is critical to their successful reentry, but the prospects for work are daunting. The National Resource Reentry Center has logged barriers numbering over 40,000 for those reentering society. Nationally, 30% of individuals released from prison are unemployed after 2 years. Formerly incarcerated are 5 times more likely to be unemployed and earn 40% less annually. And a criminal record reduces employer callback by nearly 50%. All of these sobering statistics have a disparate impact on communities of color. And we hope to address some of the barriers today, but also provide some solution-oriented approaches. This discussion is particularly timely as April has been deemed by the White House to be Second Chance Month, a time where we commit to build a more fair criminal justice system and help folks returning to their communities from jail or prison have a fair shot at economic opportunity and advancement. So I'm excited to gather these experts in the field for this discussion with a multi-state perspective and also present new research by my colleagues on these issues. First, my colleague and friend, Matt Salah. He's the Director of Research at the Criminal Justice Employment Initiative. His research focuses on career pathways and workforce development for youth with barriers to employment. At Cornell, Matt teaches undergraduate courses in disability studies and a course on mass incarceration in the United States. He is the principal investigator on the U.S. Department of Health and Human Services funded project Improving Vocational Rehabilitation Outcomes for Out-of-School Youth Involved in the Justice System, and a principal investigator also on a program called Pro Se, Empowering Justice-Involved Youth and Young Adults Through Speech, Debate, and Self-Advocacy Training. Matt also is a faculty advisor for the Undergraduate Mock Trial Association and is a Fulbright Scholar. Next, I'm excited to introduce Deborah Blackburn. She's the Assistant Director of the Utah Department of Commerce Division of Professional Licensing, which oversees approximately 60 categories of professions and several independent programs. Deborah joined DOPL after 20 years in private practice as an attorney, and as a second career, loves figuring out how to remove unneeded barriers to licensure and effectively balance regulation and public protection. Last, but certainly not least, our third lawyer on the panel, Jason Hogue, has established a reentry project for the Rochester Office of Legal Assistance of Western New York. In this role, he represented individuals with prior convictions, navigating various legal forums to help them overcome barriers and stigma associated with criminal records during their reintegration into society. In recognition of his outstanding contributions in the field of reentry, Jason was honored with the New York State Bar Association's Denison Ray Award, acknowledging his extraordinary commitment to providing creative, skilled, and zealous representation to low-income and disadvantaged clients. clients. Jason also contributed as a practitioner in residence at Syracuse University College of Law, where he focused on criminal defense clinic work, and he's also a former assistant public defender and at the Wayne County, New York, as well as Monroe County. So with that, I'm excited to start this discussion on occupational licensing. I'll turn it over to my colleague, Matt Salah.
Okay, hello everybody. So thanks for being here with us. So the structure of this webinar is going to be a little bit unique in the sense that we're going to start by laying a little bit of context for occupational licensure issues in New York State specifically. Then we're going to go to Deborah Blackburn for kind of a counterexample or a different example from the state of Utah, in part because every state's a little different in this regard, right? So no two states are going to look quite the same in how they handle issues of occupational licensure for people with criminal convictions. And then we're going to actually go back to the true subject matter expert from New York State in Jason Hogue. So we're going to go New York, Utah, then back to New York. So before delving into the true subject matter experts here, I wanted to give a little bit of background on like what is actually the problem we're talking about in New York State specifically. As we know, New York recently became a clean slate state, right? Where our new clean slate law comes into effect in November, I believe. So one thing we're looking at with this is what's the scope of clean slate as a way of rectifying some of these issues, some of these barriers to work for New Yorkers with criminal records. And where are the gaps? Where are the things that it's not going to address necessarily as holistically as maybe it could? So to start with, some might be surprised to know that New York actually has 500 separate laws and regulations restricting access to work for people with criminal convictions. That's just a number, right? We don't know exactly that. Just seeing that sounds like a lot, right? But one thing we're going to talk about is what's the scope of those restrictions? How well tailored are they to actual public policy objectives of making sure that workplaces are safe, clients are safe, things like that. So of these 500 laws, 20% of them are mandatory, meaning that they are automatic restrictions to entering certain professions. And often they apply from our own research, which there's an accompanying policy brief for this work. We found that many of them apply to a broad category of felony convictions, in some cases even apply to misdemeanor convictions. One of the points that we're going to make up front here is, I would say we use the terminology broad here up front. I would say often overbroad. Often they include certain types of felonies that are not related or substantially related to actual job duties that people are going to carry out. Others are discretionary in nature, which means that someone somewhere has the capacity to review a person's criminal conviction record and make a choice based on what they see, whether the person should or should not have their license approved. I think our guest Jason is going to talk a little bit about the fact that, you know, discretionary, in some ways there's benefits to discretionary policies, but they're not, that doesn't mean they're perfect. That doesn't mean that just because there is discretion that often it's used in a way that's necessarily ideal. So in terms of what, so as part of the research we did, right, we were looking at which industries and sectors are regulated in New York State and why. The short answer is that there's a lot of different types of occupational restrictions. Some of them are highly broad in industries that we know are very robustly regulated, right? So financial sector jobs, healthcare sector where you have vulnerable clients in play, childcare, schools, anything where there's perceived to be a heightened level of risk around hiring, right? So some of the laws in New York, and this isn't just true in New York, this is true in other states, this is true at the federal level as well, will broadly restrict large industries like banking, right? Or respite care. Other examples are much more specific. So they'll look at specific occupations that require certification. Lawyer, accountant, private investigator, real estate agent. Those are some of the common ones you see in New York and elsewhere. And then others restrict access to business licenses or permits, right? So within those 500 different laws and regulations, you're seeing a lot of different piecemeal lawmaking that bit by bit restricts the types of jobs a person can receive if they have felony convictions or certain felony convictions. We initially we came into this topic, we actually were starting to look at it from a national level, right? At the federal level, what's the trend in terms of passing laws like this that say that restrict access to certain types of occupations? One thing we found is that in the United States, more broadly, this chart is actually from the United States. The cumulative number of legal restrictions to work actually grew in a way that's shockingly correlated with the rise of mass incarceration in the United States. So starting around the 1960s, 1970s, the cumulative number of federal restrictions grew over time in a way that you can see with the kind of overlaid graph here, chart here, that there was a very strong correlation. This is actually from a separate paper that we have coming out in the Harvard Human Rights Journal, I think in a couple weeks. So other thing to think about here is, so within New York State context, when we're looking at clean slate, and I'm going to let Jason go into more detail about this, one of the areas of clean slate that's I think been slightly under discussed is that it doesn't, records that are covered under the law do not necessarily seal um, um, automatically when it comes to jobs that have federal or state restrictions on the books, right? So all of these laws that still exist, they mean that there still is going to be fingerprinting. There still are going to be background checks for jobs, for instance, in the Department of Health, in certain regulated financial sectors, for jobs requiring professional licensure, right? So one thing we're going to talk about is the fact that these laws still matter. Clean Slate didn't make these 500 laws that are on the books in New York State suddenly defunct and no longer relevant. So another key point I wanted to just lay as part of the groundwork is, and I'm trying to be mindful of time here, is that in New York State, there hasn't yet been a holistic effort to address this issue, right, of potentially overbroad occupational restrictions that artificially limit the job market for people who are returning to society, or in some cases, people who never were even in a carceral setting, right? And maybe they were on probation, but have a relevant conviction of some sort. So the efforts to date at a state level, which isn't to say they aren't admirable efforts, but they've been largely piecemeal, right? There have been small instances of laws and regulations being updated to more accurately reflect job-related duties, things like that. I have a couple of examples here from the New York Code. But many of the rules remain overly broad and not tailored to specific offense types or job roles. I'm actually going to, right before handing it off to Deborah, I'm going to give just a few examples of what these laws actually look like. I'm pulling the actual legal text because I think sometimes these are nuanced issues, and I think it's helpful to see, okay, what do these restrictions actually look like? What does the plain language of the text actually say, of the law actually say? So these are some of the things we looked at in our research. And in general, we were asking ourselves, if you take it holistically, look at all 500 of these laws and regulations, how well tailored to public policy interests are they? What I mean by well tailored are they based on, do the law mandate that you look at the type of felony and connect it to actual job duties, right? So all felonies should not be covered by a single occupational restriction, right? Because all felonies are not relevant to all jobs, right? So that's what we mean by narrow tailoring, is making sure that there are efforts in the writing of these laws and statutes and regulations to make sure that there's an actually defensible public policy reason for why they are written the way they are. So other things we considered is the duration of the restriction, right? There's a lot of evidence out there to suggest that time is a strong predictor of whether a person is going to reoffend, of the types of risks that are often overblown in occupational contexts, right? So all of these laws, we say in the brief, should have some kind of durational limit. It could be pinned to clean slate in the same number of years there, or something that's rationally related to our understanding of the fact that the age that a person was when they committed offense matters, that the amount of time it's been since they committed the offense matters. So these are all things that are types of narrow tailoring, right? Ways of making these laws fair and equitable, but also rationally related to their objective. And I'll just add to that one thing that's really interesting when you look at this type of lawmaking is the fact that these are often smaller provisions or smaller regulations within much bigger lawmaking efforts that weren't necessarily about, access to the insurance adjuster profession, right? As an example, right? They're often like little stingers, kind of in all these different types of lawmaking. They're often not within the criminal code. They're often within labor law, healthcare sector law, finance law. So the result of that is a lot of laws that in my reading, I'll just keep it specific to myself, they're not they're not integrated with one another. It's not thinking about like what's the collateral damage caused by having 500 different little laws like this. So before I hand it over to Deborah, I'm just going to give a couple examples. As I said, I think if you're new to this subject, you might want to actually know, okay, what kind of thing am I talking about? What are some of the linguistic issues that we might want to look into? Here's one for insurance adjusters, right? And if you read the text, the law, it says, no license shall be issued to any person who has ever been convicted of a felony or of any crime or offense involving fraudulent or dishonest practices. Nor shall a licensee employ any person who has ever been convicted of a felony or such a crime or offense. So those of us who went to law school, those of us who are interested in the language of statutory drafting, you can see a lot of problems in there, right? It says, no license shall be issued to any person, right? It's a mandatory restriction, who has ever been convicted of a felony, period, or a felony that's involves fraudulent or dishonest practices. Linguistically, that's a huge, that's almost, you want to go so far as to say, is a little bit of a mess, right? Because you have that or conjunction in there, but basically in a plain reading, that covers any felony ever, right? Regardless of how distinct it is from the job duties of an insurance adjuster. And this is from New York State, just to be clear. Radiologist, right? A similar example, no person convicted of a felony shall hold a license to practice radiologic technology unless he or she has been granted an executive pardon, certificate of relief, or the commissioner at their discretion restores the license, right? So again, convicted of a felony, that could be a drug felony from 20 years ago. There's no durational limit mentioned anywhere in here. And these are good, upwardly mobile jobs that a person can be trained to perform, right? So that lack of specificity is a huge problem. Other examples, I'm not going to read these all verbatim, right? But security guards, this one's, at least it specifies serious offenses, right? So you can give it that quality, that qualification. Other states go much deeper. They say if you have committed a crime, that they pin it to the code, to the criminal code. They say specific, what do we mean by a serious offense? We mean X, Y, and Z provisions within the criminal code, right? So even within serious offense, there's opportunities for misreadings, right? And here at least, right? So it should be a little bit alarming. This is a good example compared to the other two examples. This is actually a better example, right? They at least say that bears a relationship to the performance of duties of security guard. We're going to talk about Deborah in a bit is going to talk about like what are some linguistic ways that you can actually make sure that it's substantially related to job duties, not just bears any relationship whatsoever, right? And then the last example, so respite care, this is a big one in New York because there are currently labor shortages in the context of in-home healthcare, respite care. But this one's a little bit more well-tailored, right? It actually says client abuse or related felonies, right? So it's actually at least getting a little bit closer to something that's truly job related, right? And again, in the respite care context, you're talking about vulnerable populations. And my last example, and I include this one just to show you, how different these different provisions look on paper, but also how even the flaws in them are different from regulation and provision to provision, right? This one is an instructor of a motor vehicle accident prevention course must have not been convicted within 10 years prior of becoming an instructor of a felony or crime involving violence, dishonesty, degeneracy, moral turpitude, deceit, theft, forgery, making false written statements, rape, perjury, fraud, or bribery. So basically any offense imaginable that is not a driving offense, right? Which that shows you some of the discontinuity in the way that we're thinking about these things. Are they well tailored to what they're actually supposed to be accomplishing, which is increasing the safety of certain certain employment contexts. So I'm picking out certain specific examples there, but I feel like it was necessary to set a little bit of groundwork so we understand the problem. So I think I hopefully have conveyed that there is a problem in New York, right? So with that, I'm actually going to hand it over to Deborah Blackburn to talk a little bit about Utah's efforts, which the main thing to understand here is that Utah is in a slightly different place in considering this problem than New York is. So Deborah, I'll hand it over to you. And I'll stop sharing now.
Yeah. So yeah, thank you. That was really interesting to look at the language of those different statutes. Wow. So yeah, as you mentioned, Utah is, I'm sure, is very different in a lot of ways. One thing, our Utah's our Division of Professional Licensing in the Department of Commerce. We're what's commonly termed an umbrella agency. So we oversee 60 plus categories of licensure. It ranges from physicians and surgeons. We've got architects, engineers, cosmetologists, nurses, construction trades. And we have about 3 investigations teams that covers Utah that's totaling about 40 investigators. So I hadn't realized when I came to Doppel just how different that is from other states. And there's some advantages and there's some disadvantages of being an umbrella agency. And I'm sure we'll talk about those later. But so just diving into it, I'm going to try to cover a lot in a short amount of time. But so our mission is to strengthen trust in Utah's professional workforce through effective licensing, balanced regulation, consumer engagement. And it's that balanced regulation that we've really been trying to hit. So we absolutely want to protect the public. I mean, this is why we're here. We can do a lot as a government agency that you just can't, you don't have the power, the authority to do otherwise. But we also want to remove unneeded barriers to licensure. And so it's always trying to find that balance, and things shift a lot over time. So I joined Doppel mid 2016, and at that time for licensing and our disciplinary decisions, so per statute, we had to consider whether a person's criminal history was, quote, reasonably related to their ability to safely or competently practice. And in 2019, there was a bill introduced, and it was very complicated. They wanted to do a lot of things. And our director, Mark Steinagel, he said, why don't we just change this term reasonably to substantially? That will, in one word change, it will accomplish what you're really trying to do. And so this is a whole new lens. And so we now ask, is the criminal history, is it substantially related to somebody's ability to safely or competently practice? And I joked when this passed, it's like one small step for man, one giant leap for mankind, because reasonably related, you tend to go down the rabbit hole, is what we found. We're trying to protect the public. So what if a cosmetologist is convicted of theft? Well, they can get in somebody's purse, What about a CPA that gets a DUI? Is that going to affect their ability to, work for their client? Substantially just gives you that better tipping point where you can focus on what's important in protecting the public. And so we just let people work who are actually able to safely work. So this is a significant shift in philosophy, and it guided our next efforts. So yeah, what exactly is substantially related? It's my joke is who's going to bail the cat? So what we did is we sent letters out to each of our 50 plus boards, and we met for each profession. We met with them, and it took over a year to go through that and meet with each board. And we said, so with your profession, what exactly is substantially related? And there were some really fascinating discussions, as you can imagine. So veterinarians, their discussion, they didn't care about a lot of convictions, but they cared a lot about drug convictions because they have access to controlled substances. And they have some loopholes, that guardrails that aren't available to them that are available to physicians, for example. And CPAs, of course, understandably concerned about theft, dishonesty like that. So we went with that. So we're gathering all this data, and we're trying to figure out, okay, how can we be more objective and consistent? That's our mantra, be consistent. So how can we share this with the public and our customers, the applicants, and be more transparent? So go ahead to the next slide. So we created new criminal history guidelines along with frequently asked questions to explain how we consider criminal history. And so every profession now has a landing page with a criminal history tab for information specific to that profession. So this is kind of our main page. You can see, it's hard to read. My eyesight's not great either. So criminal history guidelines. If you go to the next slide, this is an example. This is of our landing page with the tab. And so this is our contractors. There's our page. You can see there's an overview. There's our guidelines, various applications. So if you go to the next page, these are the guidelines. We call them sometimes the matrices, the matrix, a lot of jokes about that. So what we did is, again, we took this information from the board and we said, okay, here's our key across the top. The types of charges are all down on the left. So you can see starts alphabetically, and then we've got time frames across the top. We've got 0 to 1 years, 2 to 5 years, 6 to 10, and 10 plus years. And it kind of, as you said, timing, how long ago did this happen is pretty important. So what we did is we took this through. We have our disclaimer at the top because we do consider patterns, multiple convictions, but someone at least we were hoping could look at this and say, well, I have a good chance of getting a license based on, what I know my criminal history is. So if you go to the next slide, I just want to contrast this a little bit. When you look at most of our keys, you'll find out most of our guidelines are green or blue. There's a lot of, and I think it gives people some hope at least. But security guards, some professions are just more sensitive to criminal history, and many crimes are substantially related to practice. And so these security guards, they have the statutory language prohibiting second, third degree felony charges, and of course, firearm convictions if they're armed security guards. So I just wanted to note too, there's a lot of support in DOPL, as we call ourselves, for this concept of substantially related and removing barriers to licensure. So just as an example, another area of reform we've tackled is licensure by endorsement. So someone can come in who's been licensed in another state or country and get licensed in Utah and not have to reinvent the wheel just based on their existing license. And when there was some language in a draft bill and it said, it completely banned 100% somebody coming in who had criminal history from another jurisdiction. And one of our managers, who always reads everything with a fine-tooth comb, he said, why don't we just change this to a discretionary review? And that way it fits in with our existing guidelines. We can decide whether it fits into our matrices here. And so the sponsor allowed us to make that change. So we were really happy about that. So anyway, these are living documents, as you can probably tell. We revise them based on legislative changes and the input from the boards. So kind of a fun example, if you go to the next slide. Utah, forever and a day, we had an outright prohibition against licensure for nurses if they were convicted of a violent felony. And surprisingly, that was changed in the statute. So we went ahead and now it's treated like any other conviction or plea. So our landing page no longer has all that deny for nurses. A lot of it is issue and green and review. So kind of moving on to the next slide. Again, just kind of going back to our mantra, how can we be more objective and consistent? So clear back in 2020, we asked in our division bill, we don't run one every year, but typically every other year, we wanted to remove this ambiguous and subjective standard that I'm sure you've seen in a lot of places of good moral character. This was included in statute for every profession. Nobody could really tell us because you ask 5 people what's good moral character, you're going to get 5 different answers. So it took us 3 sessions to catch all of this because, if you've been in the legislative session, it's making sausage and we're hopping between everything. But I think we've got them all now. So if you go back and look at our statutes, it's focused on convictions, crimes, but we don't have this subjective standard anymore for review. I think go on to the next slide. We also have added language in the statute for individualized consideration. Honestly, we were already doing individualized consideration, I feel pretty well, but there was another bill introduced that kind of supported our efforts. And so we worked with the sponsor on this final language. So we must consider now per statute the age when it's listed there, the age when the crime is committed, time, lapse, completion of sentence, rehabilitation efforts they've done, education, training, employment history, what have they done to get training, testimonials and recommendations, teachers, parole officers, anything. And we say any relevant information they want to provide, we'll consider. So go on to the next slide. So we also, another bill, it specifically allowed us to not consider as unprofessional conduct an arrest not followed by a conviction. And with some exclusions, if the incarceration has ended more than 7 years before, we won't consider those either. And we also won't consider expunged crimes. And historically, we were one of the agencies that had authority to consider expunged crimes upon request. But we developed an informal, unwritten policy that we did not consider them. And a sponsor came to us one year and said, we're considering removing you from the list of agencies that doesn't that have authority to review these. And we pulled our managers and they all said, yeah, take us off the list. We never look at these. We don't want to look at these. Why would we second guess the court's decision? It's not our place. So if somebody's already served their time, let's just move forward. So a lot of this, I've summarized it pretty quickly, but a lot of it is just working with sponsors who come with language, and then we work with them to kind of make sure that it fits within what we're doing. And luckily, it's worked pretty well so far. So I'm going to say, if you go on to the next slide, another area we've tackled, trying to be objective and consistent. We have a criminal history questionnaire in all of our applications. All of our applications, the first couple pages look the same. And one of them is criminal history questions. And when I joined Doppel, this is what it looked like. I don't know if you can read some of those questions, but I'm going to read one because it's just so almost useless is kind of how we felt. This is, are you currently using or have you recently within 90 days used any drugs, including recreational drugs, without a valid prescription, the possession or distribution of which is unlawful under applicable state or federal laws? If you answer no to that, you falsified your application. It's unprofessional conduct. You're subject to discipline. We could not grant the license. So if you switch over to the next slide, what we did, this is our new questionnaire that's on now all of our applications. It pares it way down. We took out all those extraneous things and we focus on, have you ever had disciplinary action on a license or in other jurisdiction? Do you currently have any criminal action active? Anything pending? Have you, within the last 10 years, have you pled guilty to plea in abeyance for a misdemeanor, or have you ever been convicted and entered a plea for a felony? That's it. That's all we ask now. So kind of takes away a lot of that gotcha and a lot of that concern for answering those nebulous questions. So let me go on to the next slide. So I call this last but not least. I really love this. We have a pre-licensure criminal history determination. And this lets somebody, an individual can come and they can ask Doppel if their criminal history, their specific criminal history would impact their ability to get licensed in a specific profession they're interested in. And this determination is available even before they pursue any education or training. They just submit the form and say, this is what I'm interested in. This is my specific criminal history. Please let me know. So they submit the application, we review. We're supposed to issue a determination within 30 days. First 30 days, we were a little concerned because we are an umbrella agency. We run on a shoestring. We do a lot with a little. But the 30 days has actually worked out okay for some. So they issue that, and we just tell them, would your crimes preclude you from licensure? For fun, again, we're a small state. I'm sure our population numbers don't look at all like yours, but to date, we've received 188 applications, and most of these have been favorable. I counted up this morning, we have 23 unfavorable, but most of those are because people don't finish. They submit an incomplete application. They submit something, but we follow up and say, we need your records. You haven't submitted your records. And then we just don't hear back from them. So I would say probably maybe we have 8 hard denials where we say you can't get your license. And a lot of these are favorable. We say, well, okay, your criminal history is pretty severe, but what we would do is we would put you on probation for a period of time. We'd probably place a hold on your license at renewal to double check that you didn't have any other criminal history at that point. So I think, and most of our professions that use this, nurses use it the most, contractors, I would say second, third is cosmetologists, massage. Those are higher populations, and the contractors tend to have the most severe offenses. They can work in their field, with more severe criminal history. So yeah, just to summarize, we've last few years, we've put in some major sea changes in our consideration criminal history. I think we're working hard to be more objective and consistent and try to be transparent. I don't think we're perfect, but we're always trying to improve this and make it better. And so we just want to protect the public, definitely, but remove unneeded obstacles. So just let people work in their career of choice. I think, yep, thank you.
Great, thanks, Deborah. So within there, I mean, I saw like two kind of separate streams of streams of ideas that are relevant to New York in context. One is that there was actually the statutory changes around around the substantially related language instead of reasonably related language. There was a much bigger emphasis on durational limits. The thing about expungement was not looking at expunged records was interesting. And one thing I've noticed is that there's different expungement is used in different ways in different states, I feel like, or in different contexts. Sometimes New York's clean slate focused on record sealing, but I feel like that's actually what expungement means in some of these lawmaking efforts. But I did have a
If you
follow-up.
go, let me see if I can put this in the chat. Let me see. This is our guidelines. We found in our expungement, we have frequently asked questions. The section on expungement is quite long. We tell people expungement is different in every jurisdiction. Please disclose, always better to disclose. And you can, if you have, I was going to joke, if you have problems sleeping, you can go read through that. But we have links to assistance as well. Our Utah State Bar, has free expungement days, and the mayor's office in Salt Lake City has information. So we try not to only talk about expungement and give a little bit more information on that, but here's some resources that could assist you, because maybe you can get this license if you go and get this expunged.
Yeah, great, thank you. And then in addition to this, so before we go to Jason, in addition to I want to kind of set the stage for what Jason's going to speak to is, so I saw the legal changes and the statutory changes, and then I also saw some practical solutions like pre-approval processes. And there's one that sticks out as a pretty big difference between Utah and New York, which is that compared to New York, Utah appears from what I'm seeing to have a more centralized licensing agency and licensing process as compared to what we see in New York, where it's a little bit more departmental for certain professions and things like that. I wonder if you could explain, just because that might make New York a little tougher to implement some of these things. Has that been a big part of what has made a difference in Utah? Is that centralization?
I think absolutely that's one of the pros of being an umbrella agency and the centralization. We can do a lot with a little and make things uniform across the professions. Of course, every profession is different, and we try to honor that, but there are some basic standards that we can implement that cover, as I said, we have such a broad swath, everything from physicians and surgeons to nail technicians. So
Great. And then so I had one other question just before going to Jason, and we're doing pretty well on time. What just in terms of learnings, what would you say have been some of the biggest challenges of making this pivot for your state, and what have been some of the things that at least on a personal level, you feel like have been the most successful or biggest part of the success stories?
I would say, let me talk about the success first. I think the paradigm shift, just by making that change for the language from reasonably to substantially related, you start from that point. I think that made a big difference in how we were able to look at it in criminal history in the first place. The criminal history predetermination, I've asked our managers, and I felt that was one of the most helpful things we did, and they agreed. They said, yeah, people really love the security of having that, because we will stand by it. Laws, we warn them, laws can change, and it's based on your application at that time, and we're going to consider anything that you haven't told us about it when you finally do submit the application. But just to have that security, to be able to go to school and know that you can, that gives you so much hope, I think. Challenges, I think, because one of the cons of being an umbrella agency is resources. We thought, oh, here's this ideas, let's do it this way. Our matrices were actually based on one of our bureaus that had used that for an internal screening, and we thought, oh, that's great. I think that's been less successful because it can't be that individual, and also it's very public facing, and so and because of resources shifting, trying to get somebody to update that has been difficult. So we wanted to update every year. But last year, for instance, well, no, just in this legislative session, we had a senator run a bill saying you have to annually update your matrices. They were upset because we had listed sodomy in there, but we hadn't drilled down enough to say forcible sodomy or sodomy on a child, which were the actual offenses. And so we said, okay, just playing nice with the legislature. We're like, okay, run the bill. But then the governor vetoed it. And in the veto letter, he said they did this on their own initiative without the statute. You're putting this restriction in statute. But he said, Doppel, you are going to do this. Doppel can and will do this. And of course we want to, but I think sometimes, but really my philosophy was perfect is the enemy of done. So we had to start somewhere, and we actually were able to hire a new legal analyst in December, and this is going to be one of his tasks. And he's already got some ways that we're going to update this and make it better. So yeah, stay tuned. We'll see how it works out. But I think this gives a lot of people hope. So.
Great, thank you so much. And I think so now we're going back to New York State with Jason Hogue, who has much more direct experience with some of these challenges in New York. So I'm hoping that the listeners and the viewers can kind of compare and contrast a little bit what Jason's describing with what we just heard from Deborah. That's kind of the point of the structure. So Jason, I'll hand it over to you.
Thanks, Matt, and thank you, Deborah. It was really interesting, listening to that, because I'm hearing so many differences. What I'm going to talk to you guys today is about specifically New York's law, because New York actually has some very unique laws and actually some great laws. I think the problem is what Matt was talking about is integration, is we don't see these great laws being integrated in some of these decisions, which is actually required. So what we're going to talk about is, professional licensing and also occupational fields. So there's whole fields like the medical field, being a certified nurse's aide in a nursing home, or being a bus driver for a school bus. And those are not necessarily specific license or professional license you have, but it's an occupation that's regulated by the state. And what we're going to find when we do this, sorry, I'm getting called as always. I am a practicing lawyer as well, so people calling me. But so what we'll find is New York actually has some wonderful laws, and they apply both to the state when the state is doing professional licensing, moral character and fitness reviews, also these occupational background check clearances, as well as the private sector is fully covered. And in terms of the laws we're talking about specifically, this is New York State's corrections law, Article 23. And this is actually not a new law. This is actually quite an old law. This goes back to the 70s. I always like to point to the legislative history, because if you read it, it really does read like it was written today, which is we spend an exorbitant amount of money on the criminal justice system. And the expectation there is when people complete, their interactions or participation in the criminal justice system, is they're going to be welcomed back in the community. They're going to be able to get stable housing, to get, education, to get employment. And this law found that there was problems, and the law was meant to address those problems. And the law actually applies both to the state, when the state is doing a professional license decision, or whether it's doing clearance background checks for, say, medical field or educational field, or any of these kind of protected vulnerable populations. And it also applies to private employers. And what the law says is this, which is it's unlawful discrimination. And I always like to point out that term, unlawful discrimination, exactly the same term that's used for race discrimination, gender discrimination, religion. So it's meant to be something stamped out by the community, by the state, by society. And what the law says is that it's unlawful discrimination for the state or a private employer to deny an individual employment or professional license based solely on the fact that person has a criminal record. However, there's two exceptions. And the two exceptions are here, which are whether there's a direct relationship between that conviction and the job. And direct relationship, while it's not actually defined, I often say it's very common sense. I have a law license. I'm licensed by New York State Bar Association, and they do a moral character and fitness review on me. And if I say, let's say a client brings me money and I'm supposed to put that in an escrow account to maybe do a real estate transaction, but instead I go to Jamaica. That's embezzlement. That's a very specific type of crime. And what if I'm convicted of that crime? I probably will have my license removed. And what I'm going to be told when I try to go get my license back is there's a direct relationship. You had a law license and you use your license to take a retainer from someone and you use that money illegally. That's a direct relationship between the crime and the profession. Unreasonable risk. Unreasonable risk is much more vague. And you can see how that could be used kind of very, in terms of, oh, this person has a petty larceny from 5 or 6 years ago, and they want to be my cashier at my store. That's unreasonable risk. Well, that's actually not how the law works. And it works this way both for a direct relationship or for unreasonable risk. What that employer or that state agency must review and decide and determine and weigh is that when they're deciding if there's a direct relationship or unreasonable risk, they must apply these 8 factors. And we'll find there's actually 9 factors. And as you saw, it's actually very similar to the factors that Utah is using. One, and it's an important factor. I've actually seen cases decided on an employer not actually reviewing this first factor. It is the public policy of New York State to encourage people formerly convicted of crimes to get employment, to get education, to get licensure. And anybody in the state, acting against that is acting against the state's interest, our interest. And next, the employer or state agency, they must look at what are the specific duties and responsibilities of that job, and how, if that any way, is that actually related to the licensure or employment the person's trying to seek. And next, what is the bearing, if at any at all, on that conviction, the ability for that person to have the fitness or the ability to perform one or more of the duties. So what the law is saying is, look specifically at the job, what's the connection? And then the next factor, the time elapsed. How long ago? Was that 10 years ago? Was that 5 years ago? Was it 2 years ago? Was it 1 year ago? And then in that same vein, how old was the person at the time? Was that person 19 or 20, or were they in their 40s? And then next, the seriousness. Was that A felony, the most serious of serious crimes? Or is that B misdemeanor, the least serious of a criminal conviction you can have? And then next, the employer or the state agency must allow the individual to provide evidence rehabilitation. That could be drug treatment, anger management, payments of fines, volunteering, activity in the faith community. It can be a multitude of different things. I once had a client who brought me poetry they wrote, and we used that as evidence of the individual's rehabilitation. And finally, but I don't think it's the most important factor, it's one of 7 factors, or 8 factors, I'm sorry. That's why I went to law school. Math is not my strong point. So the last of the 8 factors is the employer, the state's interest in protecting, the public, their staff, their property. But that factor doesn't overrule the rest of them. And then finally, there's actually a 9th factor. And that's whether the individual who's applying for that job or that professional license, whether they hold what's called a certificate of rehabilitation. And there's in fact 2 certificates. One's called a certificate of relief from disability, certificate of good conduct. I won't go into that because that would be another lengthy discussion. But what you need to know about that is they're actually very powerful. So what this certificate does is upon issuance, and if it's issued in the most unrestricted manner, it literally restores every single right that was removed from that individual upon their conviction. So I think Matt was talking and giving some examples of, like, say, a security guard who's convicted of a felony, and it doesn't matter when or what it was, will be disqualified. If that individual has the certificate, it reverses that disqualification automatically. Doesn't mean they have a right to the job. Then the law kicks back in. And so with the employer, that state agency would say, okay, this person was under an automatic disqualification. They have the certificate. It lifts the automatic disqualification. And now what that state agency should do is review the rest of the factors and make a decision in compliance with Article 23A. So you might see an individual felony conviction, say for burglary second from 1980. They get licensed, they try to get licensed security guard. They're going to be denied. And then what they would do is they would present their certificate. It would reverse the automatic disqualification. And then the state would then apply those 8 factors we went over. And then the next thing the certificate does is it actually provides the person a legal evidence of their rehabilitation. It's a legal evidence in terms of a rebuttable presumption that the employer or state agency can rebut. In connection with corrections law, Article 23A, is New York State's human rights law, 296, subsection 15. And so this is where you'll find all protections against discrimination, gender discrimination, race discrimination, you name it. And in there, specifically a law that states, again, it's unlawful discrimination in the state of New York to deny somebody either professional licensure or employment. And this applies both to the state and to the private workforce based solely on a criminal record. What the statute also does is it gives a enforcement mechanism, which is the individual can bring a case to either the Division of Human Rights or to the state courts if it's a private agency. One of the issues we do see, which is that there's a second, if the say the agency was not a private employer, but it was a public agency that denied the license or job, then it actually has to be brought in the special proceeding, which is called Article 78. I won't get lost into here, but what's to know is it's actually a very difficult proceeding to bring. And mainly that is because there's 4 months of a statute of limitation. So usually when somebody gets denied a license, it takes them a while to even figure out maybe they have any rights. Then they need to go find maybe some agency that would help them on that issue, if that even exists. And by that point, we usually find when people get to our office, 3 months, 3.5 months are gone. And it's very difficult to challenge a state agency with that period of time. And so we find a lot of times it's really, even though there's these great protections, a lot of times it's unenforceable against the state, even where we clearly believe the state made maybe not a decision that was compliant with the law. Another wonderful law here is New York Human Rights Law, Article 296, subsection 16. And what this law says is that in New York, it's actually unlawful in either employment, professional licensing, or housing to ask somebody, hey, you ever been arrested? Tell me about all the times you ever been arrested. Because as we know, I'm a former criminal defense attorney, people get arrested all the time and the cases are dismissed and then they will be sealed. Because in New York, unless you're convicted of a crime, and a crime in New York is a felony or a misdemeanor, okay, you do not have a criminal conviction. We find, and I'm a former criminal defense attorney, people get charged with felonies, get reduced to a misdemeanor, go back to court, and they plead to a violation. And these violations are actually automatically sealed. And so people are charged with crimes, ultimately plead out to what's called a violation, that record's sealed. Or people choose to, use their rights. They go to trial, they're acquitted, the record's sealed. Or the case is dismissed because it was not a legitimate arrest, case is sealed. Or people enter diversion programs, they do drug treatment, do anger management, and the case is then sealed. Or they're a juvenile, they're under the age of 19. They're then adjudicated a juvenile, the records are sealed. And now, as we'll talk about more later, because now there's sealing statutes, if people seal their convictions, they're protected under this. So if an individual has been arrested 15 times, and let's say convicted of 2 violations, but never a felony or a misdemeanor, then it would be unlawful for them to be forced to disclose that information. Or let's say if they were convicted of a felony 30 years ago and went back and had that record sealed, it would be unlawful for a state agency or a private employer to ask about that information or use that information against them. Another law I'll cover really quick. This is the Fair Credit Reporting Act. I just want to mention this because most employers, when you're talking about not outside the state agencies, how most employers actually get people's background checks are through consumer reports. They're actually not taking people's fingerprints. They're actually not going through these governmental agencies. They're simply buying the person's record from the court system through a consumer reporting agency. And the Fair Credit Reporting Act governs how that's done. And basically, it's pretty common sense, which is that you have to tell people you're going to do a background check. They have to authorize it. And when the background check comes back, you have to give the person an opportunity to dispute the information. Because what we see as professionals here is that these records are often inaccurate. They often have errors in them. And so we see people, coming back with records that should not have been disclosed, or maybe not even their record. And so don't want somebody losing a job because simply the reporting agency reported the wrong information. Sealing convictions. So when I first started doing this work in the early 2000s, if somebody was convicted of a crime, that being a felony or misdemeanor, they were going to go to grave with that conviction on their tombstone. They're just literally in New York for up until 2009, if you were convicted of a felony or misdemeanor, there was no way. There is no expungement in New York, and there was no sealing. And so if you were convicted of a crime, no matter what you did with your life, how much you changed, you would always have a criminal record. And so that started changing and started in 2009. And that was the first statute, which is CPL 16058. It's very specific. It's really underused, I think. I've 15 years of practice. I've done it once. And you really need to have a very specific type of record. You need to have a drug conviction, and not just any drug conviction, a Penal Code 220. And then you had to go to court and be judicially sanctioned to a drug treatment program. You had to complete that program, and you had to not be arrested again. And unfortunately, when we see with people with criminal records with drugs, often their records are a mishmash of a bunch of things: prostitution, petty theft, drugs. And so sealing a couple of drug convictions out of, a rap sheet of 20 convictions of different stuff was not all that helpful. The second statute, CPL 16059, is actually a statute I use quite a bit. And this allows people to seal their records in New York if they have no more than 2 convictions total, no more than 1 felony. And it can't be a violent felony offense, and it can't be a sex offense. And it must be 10 years after the date of either they were convicted or released from incarceration. We actually do that quite a bit. It's a very underused statute. And what we'll talk about in a second here is that these statutes, also the Marijuana Regulation Taxation Act, they seal completely. They basically seal the person's record for 99.9% of all of the public and state. So if a person has a fingerprint background check and they had a seal under this, it won't come back. The only time these records, if they're sealed under these statutes, are permitted to be accessed is if the person's trying to get a handgun. So they need to get a handgun license. And that's true of anybody arrested. So if you're arrested, you will have to disclose that you have arrest information, whether you didn't get convicted, whether you got convicted and the record was sealed. And also law enforcement. So if you want to be a law enforcement agent, again, you have to disclose every time you were arrested, whether or not it was sealed. Marijuana Regulation Taxation Act is actually the first time in New York where they did automatic, where these statutes you see above, you actually have to apply. And we find that really is what limits people, is because they don't know how to do it. It's actually quite difficult. And you're not supposed to have a lawyer, need a lawyer, but a lot of times you do need a lawyer, and there's just not lawyers will do this for free. But the Marijuana Regulation Taxation Act, which was in 2021, legalizing marijuana, basically made it so anybody with a Penal Code 221, which was specifically for marijuana, they just went through the system and they sealed all those convictions. Nobody had to do anything. So if somebody had a 221, it's automatically sealed. And then finally, I'll close up here with Clean Slate, which is going to be a fantastic new improvement forwards. There are some limitations. It's not going to affect. It goes in effect 11/16/2024. And the state will give itself 3 years to actually implement the law. So if people go check their records on November 16, 2024, they might be disappointed to find out the record's not sealed yet. And that's because the state's giving itself 3 years to do it. What that law is going to do is seal the records of basically all felonies in New York, with the exception of A felonies, which are the most serious of serious crimes. We're talking murder in the first, arson in the first, with the exception of drugs. So if it's a Class A felony drugs, that would be sealed. But all other Class A felonies will not be. And no sex offenses. Sex offense, felony or misdemeanor, will not be sealed. But that's a lion's share, 90% of felonies, and then really almost all of misdemeanors as well. It's not a sex offense. It would be 8 years from if the person is not sentenced to incarceration from the date they're convicted, or if they're incarcerated from the date they're released. If for misdemeanors, it's 3 years if no incarceration, or if incarceration, 3 years from the date they're released. One of the big issues we're finding is, though, it will not seal for agencies that do fingerprinting. So the Department of Health, school bus drivers, and so individuals will still have their records reviewed for that. So I'm going to hopefully open up here for discussion, because I'm happy to talk about the differences and individual cases. Anonymously, I could share with you individuals really running some big issues.
Thanks so much, Jason. So I actually did have a question, and then we have one question in the chat. And I think I'd encourage anyone in the audience who wants to add a question, we'll do that, or we can kind of wrap things up after we do these couple. So my first question was, as you're going through the Article 23A criteria, it actually looks like the situation in New York is unique in the sense that in my reading of the occupational restrictions that I was talking about earlier, it almost seems like there's actual contradicting law in some places, where Article 23A says that you have, including state employers, have to consider these things. The laws and regulations around occupational licensing and certification say they don't mention duration limits. They don't mention that you have to consider time since offense. They do have overly broad categories. How does that play out in real life? Like, first of all, do you consider those contradictory, or is there some way that Article 23A is covering different territory than some of those occupational restrictions? Secondarily, how does it play out in real, if it is contradictory, how does that play out in real life when somebody applies to work with the DOH, for instance, or something like that?
I mean, it's not a good answer, but it is and it isn't. For example, so I would say how they should work in immigration. So where there's an automatic disqualification, let's say security guard. If you look at corrections law, if the person gets a certificate, reverses that, and then the state should go through the factory. How does it work in real life? I'll give you an example, which is I had a young man once who actually a very bright young man. He ended up dropping out of college because he found out that he had schizophrenia. And so it came on when he was actually in law school. So he dropped out of law school and took some time to his own. And what happened there is that he had a full meltdown. I think he was in Washington, D.C., basically went to the front of the White House, made some statements about a bomb, ended up being prosecuted for making a terrorist threat. Then decides, hey, you know what I'm going to do is I'm going to go back to school and I'm going to get a massage therapy license. And so he goes to school, he does his training, he goes to apply. And this is one of the things I think is very interesting between here and Utah. This would not have happened. But so he gets through all the training, pays all the fees, and he applies for his license, and they send him a moral character fitness review. He got held up for a year on that. And when we started pointing out to like the board, like, I'm sorry, how is this related to like massage therapy? I hate to be like that, but like, how are you even getting that decision? And we also said, this doesn't seem to, reflect corrections law. They told us that was the first time they had heard the statute. I was shocked. The ALJ, of course, told them, no, absolutely, counselor's right. You need to apply the factors here at this hearing. But that's the kind of stuff we run into. That's the kind of stuff that we run into. And so, obviously, that young man's a massage therapist today, and as he should have been a year before.
Thank you. And that leads me into Deborah, did you have something to say?
Oh no, I was just nodding. Yeah, it's so interesting.
Yeah, thank you. And so I'll just lead into the one question in the chat, which I think is related, which is when you have so many different rules and regulations that can apply in a context like that creates room for error, room for human bias to creep in. So one question we had in the chat is, if you were to recommend, or maybe not make a recommendation, but looking at New York State, how do we address this? Because there are so many 500 different laws and regulations around occupational restrictions. There is Article 23A. There are other things that are meant to countervene. How do we integrate those frameworks? And I don't know. I don't know if you want to make a recommendation or just like if you have a sense about it. Like, is this something where those laws need to be kind of reformed all at once, or is it something that is it more about making sure that Article 23A is applied across the board more consistently? Like, I hope that made sense the way I kind of paraphrased the question. So I hope I did okay.
I think in terms of one point you pointed out, which was how Utah has an umbrella agency. I think that's one really interesting thing because, for example, I'm working with a woman right now who's trying to become a school bus driver. We have a school bus driver shortage. School districts are actually paying people to drive their kids to school. Kids on the streets shouldn't be walking the streets because there's no school buses. And this woman who's in her 70s has a conviction record from the 80s. Like her last conviction was in late 90s. Nothing really too crazy, drugs and theft. She's actually approved to be a child care provider and to work with elderly in nursing homes. And right now, we're trying to get her through clearance to be a bus driver, for a school bus driver. And so I think that's an example of like, how is it? And my clients asking me, how is it? Do they know that I have a daycare? Do they know that I work with the elderly and I can't drive a school bus with children on it? How is that decision consistent? So it goes back, yeah, we're not seeing consistent decisions. Another one I think is very interesting that you see in Utah is the ability to do pre-license. so many times people are getting all the way through, and it's such a kick in the stomach, to do all that work, to get good grades, to pay for that, to take a test and then say, oh yeah, that thing from 20 years ago, that's what's going to disqualify you. And I think that Utah is very much ahead of the curve, because to be able to do that would actually save a huge amount of frustration for my clients, for the advocates I work with. It would get people into jobs who should be absolutely in those jobs. And it's just super counterproductive. But I would love to hear if Deborah had some ideas too.
Yeah, it's tough just because I do come from this already umbrella agency and the integration. We've seen, I think, some of that, and you talked about challenges before. What I find are challenges, bills come through. I think our problem is trying to maintain what we've done. People make changes to other statutes and that affect what we do. And I think a lot of what we have to do now is monitor to make sure we don't lose ground. And I learned about, when I came here, there's a concept of a pendulum that swings. You know, the statutes may loosen up, and then something bad happens, somebody gets hurt, or there's some media articles, and the public perception starts to swing back, and things start to tighten up again. And I do see some signs of it swinging back here. And so I think, unfortunately, there's always, nothing is 100%. There's something bad is going to happen, and it can get blown up in the media. And so I think that's part of the problem. I think on us, it's more guarding against things fracturing again a little bit. I know that's not a great answer. I know that they have introduced some bills about employers looking at history, and they haven't been as successful as we've been with licensing. So.
Yeah, and I'll go to Jason in a second, but I also wanted to say in the national research we did, we saw a similar thing where external phenomena, like for instance, looking at the way that 9/11, September 11th, 2001 attacks affected regulation of the financial sector, regulation of the airline sector, often in ways that affect people who are so far from the concern that around terrorism, right? But it led to all these things that are still on the books 24 years later, right. Things like that. So a lot of it is reactive, and it's hard to keep up with, especially when these are small provisions in laws that are happening over time. Go ahead, Jason, sorry.
Oh yeah, no, I was just going to add to that. I mean, for example, the Department of Health regulations were really kicked off by a horrible crime. And then, but unfortunately, to decouple those things, unfortunately, horrible crimes happen in the world. Say that's horrible and it's unjust and it's wrong that they happen. But the reaction is to punish all these people who have nothing to do with that and are not security threats. And then also it really ends up harming us, because I do a lot of work in the Department of Health, and they're literally people who are not getting the treatment and the health treatment they need because there's not enough workers in those nursing homes. I mean, there's literally people dying in nursing homes. There's not enough care. And I know there's huge populations who absolutely want to do that work are prevented. And I think we lose as a community. Those individuals lose in our community. That's causing poverty in our community. But we also lose as a community because we're losing very qualified, passionate people because they made a mistake. Because they made a mistake 5-6 years ago. But also I want to point out another thing I thought was really interesting in Utah and Deborah's program is that the ability for people to go and look. The problem is I have people who have felonies from 10, 15 years ago. They think they can't be a nurse. We're discouraging people from going into fields that we need them to work because of a myth, because they think that they can't. And so I really applaud the program where people can go on and say, okay, is my conviction, is my record going to disqualify me? Because our state agencies, they won't give people advice. I understand that. They're like, listen, we make that decision at the end. We can't give you any advice on that now. I understand why the state agency is responding that way, but it's so counterproductive when certainly we have fields we absolutely need people to go into these fields. And I know, because I work with the people, they want to do the work. They would be totally great at these jobs, and they're discouraged from doing it.
Yeah. Just removing the uncertainty is such a big deal.
Yeah, so I'll add, and I think we can close out after this, just because I think we've addressed the questions. Is It's one thing that I see personally when I'm looking at this is, and Deborah kind of mentioned this, is this, that it's not a panacea. It's not going to solve everything, but
Right.
uniformity and consistency across these different legislative efforts, regulatory efforts. That's one thing that I think we are really recommending, because when you look at these 500 different laws and then you look at Article 23A and you look at the different standards, it's truly confusing even to people who are studying it. And so one thing we're recommending is like bring it in line with bring these occupational restrictions in New York in line with clean slate, bring them in line with Article 23A. These are things that can be modeled after one another, especially in a regulatory context where you don't have to go through the entire legislative process necessarily. So some of those are even more like, it seems more urgent to even fix those because they can be fixed more readily. But I really appreciate the conversation today. I think we'll round things out, and I'll just take an opportunity to say thank you again to Jason and Deborah. Thank you to Caro for having us for this webinar. And yeah, I think that's about it. I think we can call it there, and have a great day, everybody.
Yeah, thank you.
Thank you.